My name is Heather Blades, and I'm the Associate Director here at the Center for Dispute Resolution at Missouri State University. We help to coordinate this training, which is bringing together a number of presenters to share their expertise and information with you today. And today's training will focus on several topics. It'll provide an overview of the PREA standards, but it will also provide information that will hopefully help you communicate, connect with, understand, and protect the kids who are a part of your care in your work in juvenile detention. So our topics today will include an overview of the PREA standards, a discussion of adolescent sexual development, a discussion of the dynamics of child sexual abuse. There'll be a session on specific issues related to youth who are LGBTQI. And then finally, we'll talk about understanding sexual assault. So it's our hope that this information will be very useful to you in your work. And with that, I am pleased to introduce Marie Swope, who is the superintendent of the detention unit here in Greene County, and she'll be providing an overview of the PREA standards.
My name is Marie Swope. I know all of you. I have the pleasure of working with this group in the Greene County Juvenile Detention Center. And when asked about your knowledge level of PREA, the staff responded that some of them were more knowledgeable than others. I think everyone, though, has heard of PREA, or the Prison Rape Elimination Act. I'm going to start this morning with an overview to give everybody an opportunity to learn a little bit more about what the Act is, why it exists, and what the implications are. The Prison Rape Elimination Act, or PREA, was passed in 2003 with unanimous support from both parties in Congress. And that is pretty unusual in and of itself, that both parties would agree on something. And I think that speaks to the purpose of PREA. The purpose was to provide information, resources, recommendations, and funding to protect individuals from prison rape. And I guess in 2003, it had gotten to the point where when someone was sentenced to prison or jail time, that there was almost an expectation that they would be at high risk for prison rape. And actually, it actually became a joke. We have all heard jokes about, like, if you go to prison, be careful. And that's cruel and unusual punishment. That is not how it should be. So in 2003, there was an effort to turn that boat around. And it's going to be harder for some systems, and for other systems that are small and well run, it's going to be a process of maintaining a zero tolerance for sexual assault. The Act created the National Prison Elimination Commission, and they were charged with the goal of developing standards. That's how they intended to make a difference, is to set up some standards on how successful operations should look like. So the standards were completed and signed by the U.S. Attorney General and released by the Department of Justice in May of 2012. Now these standards, it took 9 years. If you look from 2003 to 2012, 9 years to develop these standards. And they were developed by people in the field, people with expertise. I was receiving emails as a superintendent of a detention center. These are what we're working on. Look them over, make comments, let us know if you have any suggestions. So they were very comprehensive, and they were developed from the field, for the field. So they were released in 2012. They became effective in August of 2012. Now, interestingly enough, it took 9 years to develop the standards, but once they were passed and signed, then we got 1 year to get them implemented. And the audit is going to start in August of 2013. So that's what this is all about. The Department of Justice has positioned compliance on the executive branch, or the governor of Missouri is responsible to certify that this state is in compliance with PREA to the federal government. Compliance is all or none. That means the Division of Youth Services, the Department of Correction, jails, etc., must all be in compliance with PREA. This is for adults and juveniles. And everyone must be working on these standards, or else none of the state is in compliance. That's what it means by all or none. And part of the standards requires that agencies, state agencies, such as the Division of Youth Services, if they enter into a contract to hold youth in a facility, that the facility must be PREA compliant. So all those kids that we are holding locally for the Division of Youth Services, the State Division of Youth Services, must be held in a facility that is compliant with the standards. And that's what our new contract with the Division of Youth Services says, that we will be in compliance with these standards. That's why it's important to know what they are and to have this training. One of the PREA standards requires that agencies, specifically the Division of Youth Services, or DYS, enter into new contracts or contract renewals only with facilities that are compliant with PREA. So those kids that we're holding for DYS, which is substantial, then the number of bed days that we provide services to DYS kids, in order to continue to do that, we have to be PREA compliant. Our current contract with DYS says that we will be PREA compliant. That's one reason to look at these standards and come up to speed and get in compliance. Another reason is that the Missouri Supreme Court Rules of Operation for a Juvenile Detention Center are currently under review. I do know, having served on the committee that created the recommended changes to those rules of operation, that PREA compliance is going to be a part of the rules of operation, ordered by the Missouri Supreme Court. That in order to comply with our own state regulations, that we would be PREA compliant. And finally, and most importantly, compliance with PREA standards is considered best practice. It is just the right thing to do. It's what we should be doing. And the PREA standards are divided into 11 components. So what I wanted to do today was to go through each one of those 11 components and talk a little bit about what each one of them means for us. And then I will talk a little bit about resources and how to implement the PREA standards. So as I go through them, you might be thinking about, well, we do that, or we're going to have to work on getting this done, or we do that, but we're going to have to tweak it a little bit to be PREA compliant. Those kind of things, go ahead and think about those, and then we can talk about them when we get to the end of the presentation, when we talk about resources. But basically, the 11 components is prevention planning, response planning, training and education, screening, reporting, response to reports, investigation of reports, discipline, medical and mental health care, data collection and review, and auditing. So the first one being, before I get to the components though, I think it's really important to know what the definition, this is about preventing sexual assault, sexual abuse, and sexual harassment. Well, what do we mean by those things? Well, those three scenarios are defined in the PREA standards. And so this is what the definitions are. Any type of contact between the penis and the genitals or the penis and the anus, however slight. It can also be penetration of the anal or genital openings of a person, however slight, by a hand, finger, object, or other instrument. Any intentional touching, either directly or through clothing of the genitalia, anus, groin, breast, inner thigh, or the buttocks of another person. Those behaviors are considered sexual assault or sexual abuse. Sexual abuse can also mean any request to engage in the activities described above, or any displays of uncovered genitalia, buttocks, or breast, and/or an invasion of your privacy unrelated to official duties or programming. What is sexual harassment? Sexual harassment is repeated and unwelcome sexual advances, requests for sexual favors, or verbal comments, gestures, or actions of a derogatory or offensive sexual nature by any one resident directed to another resident, or directed to a resident by staff or volunteer, including demeaning references to gender, sexually suggestive or derogatory comments about body or clothing, or obscene language or gestures. That's what we're talking about. So how do we, first of all, the first component is prevention planning. How do we prevent these kind of things from happening? And there are certain things that the standards outline. under prevention planning. One is the designation of an upper-level PREA coordinator. And in a small facility such as Greene County might be considered small to medium. We don't have specialized staff. We're not going to, you know, it's basically a job that will be taken on by myself in this case. I have taken on the job of PREA coordinator. We also will need to have written policy and procedures to include PREA definitions, which we just reviewed, and a statement of zero tolerance of sexual abuse and harassment. And as I already invited you to think about, well, where do we really need to gear up? What do we really need to do? I know that that is something that we're going to really need to dig in the next couple months and write what our policies and procedures are going to be surrounding these components, but they're going to be encapsulated in our policy and procedure manual, which also needs to be updated. So we really need to get everybody on the same page, and you'll see how important that is, especially with response planning. But written policy and procedures is part of prevention planning. There will be background checks and the prohibition of hiring, promoting those who have engaged in sexual abuse and harassment. And obviously, you know, to work for Greene County in the detention center, you are subject to a background check, criminal background check, and you know, we check for any kind of substantiated abuse or neglect. And so that to me, that's kind of a no-brainer, but I know how important that is and why that's in there, because if you look nationally at the problem of staff sexually assaulting, abusing, and harassing residents, we know it happens, right? We even know of an assistant detention superintendent who left Greene County and took a position in a facility that was under a consent decree. Why? Because the staff were having sex with the kids. So we know it happens. And how do you, obviously one of the best ways to prevent that is to never hire people like that in the first place. To be vigilant and to be selective about who you put in touch with the kids that are in custody. So I think that's a very important thing. Limits to cross-gender searches and viewing. This is another very important thing. Obviously, we don't do cross-gender viewing and searches, but one of the things that we need to do, and one of the things that we're making every effort to do, is make sure that we have both genders on every shift. We need to have male and female staff on all shifts, so that you lessen that need. Adequate levels of staffing, and the PREA standard, the staffing levels are a minimum of 1 to 8 during waking hours and 1 to 16 during resident sleeping hours. So that's prevention planning. The next component I want to talk about is training and education. Staff training within 1 year of employment. Okay, so that is one of the reasons we're doing videotaping this training, and we're going to do a training video, is so that when new staff start, they can get the same information that everyone is getting today. And they can be trained within, well within 1 year of employment. Also, zero tolerance policy for sexual abuse and harassment. Reporting responsibilities. Staff needs to know what their responsibilities are regarding reporting. Staff needs to know the dynamics of sexual abuse and harassment. You're going to hear a lot about those dynamics later today. Most of the presentation is going to be surrounding the dynamics of sexual abuse and harassment. How to detect and respond to actual or threatened abuse. Those are the kind of training issues we're also going to cover today, and can be ongoing training. And effective communication with residents, including LGBTQI youth. That's part of the training process, and other related topics. Not only do staff need to be trained, but volunteers and contractors need to be trained as well, according to PREA standards. So that means our teachers, our counselors, the people who come in and do religious programming, all of our volunteers will be required to view the training tape and be knowledgeable, the same as staff are. It also, training and education component covers resident education. And basically, the kids who come into our detention center need to understand that we have zero tolerance for sexual assault. They need to understand how to report that information, and that understanding, they need to be informed of those things on admission. So we do have hot off the press our new detention brochure that we're going to give kids on admission that covers these issues. It says right on here about how there is zero tolerance. It covers what they need to do to report and et cetera. And these are already part of our admission packets now. I'm kind of getting a little bit ahead of myself to resources because this was provided through the PREA Resource Center grant that we received. The same as this training is provided through the PREA Resource Grant and the training video that we're going to have. In addition to the information provided on admission to the youth, they are to have comprehensive education on responsibilities and rights within 10 days. Another opportunity that we have through the PREA Resource Center grant is the groups that we have been conducting for several months now, actually since like September. We have Melinda from the Victim Center, and she primarily talks with the kids about how to report, how to recognize sexual assault, abuse, and harassment, and some of the dynamics around those issues. And then we have someone from Forest who talks about relationships and boundaries within relationships so that they can better protect themselves from sexual assault, abuse, and harassment. So that's the comprehensive education piece. These educational opportunities for youth must be relevant for youth with disabilities and limited English proficiency. So there is money in the grant to have the brochure translated to Spanish. And we always, always, always have to keep in mind that not all kids can read, not all kids have the same proficiencies, so we need to be sensitive to that. And we have to ensure that the key information is continuously and readily available or visible to residents through posters, handbooks, or other written formats. There are some posters that we can get from the PREA Resource Center that we can hang on the wall. I think later when Isabel talks about LGBTQI youth, she talks about some symbols that communicate to youth that it's okay, that this is a safe place, and that we might want to add those. It's my thought that we might want to add those to our posters when we put them up. So that's a step that we can take and will take and need to take to be in compliance with PREA. The next component is screening. So when a kid comes in, we obviously are going to obtain information from the residents. We have a screening tool. That tool may need to be tweaked so that we ask the right questions regarding these issues. I will tell you that the Office of State Court Administrators is working on a screening tool right now for detention centers, and if they develop something, then we'll definitely want to look at that and possibly use it. The screening tool, the information that we receive from the residents, we want to assess it for risk of sexual victimization and abusiveness, and then we want to place residents in housing and in the program based on that screening. Now, of course, again, when you have a small center, you don't have too many options about where we physically place kids, but we do need to know and be aware of, we don't want to put a kid who is a shy youth, someone who has a history of sexual harmful behavior, and have them buddy up with a kid who we know has a long history of victimization. So that screening process and then acting on it is part of the PREA standards. Now, this is reporting. This is the next component, is reporting. So, okay, a kid is in detention, they have the information, they know how to report. So this is all about how do you receive reports and how easy is it for a kid to make a report. The standard requires multiple ways for youth to report abuse and harassment, including a youth grievance process. So we do have a youth grievance process. We might want to look at it and tweak it, make sure that a youth who wants to report these type of behaviors knows to use it. However, it is covered in this as well. But we have to have multiple ways for a youth to report. We also talk in here about how if a youth wants to make a report, they could talk with their attorney, their parent, counselor, anybody really. So we need to establish a method for receiving third-party reports. That is part of the PREA standards. And in order to receive third-party reports, in order for kids to report to a third party, they have to have access to outside support services and legal representation. And also, under reporting, and you're going to see it again on how to respond to a report, the youth or staff who make a report need to be protected from retaliation. Okay, so the report's made. Now what? What's the response to the report? There has to be a written coordinated response plan. And in that written coordinated response plan, which will be part of our policies and procedures, there needs to be a staff as first responder. The duties that that staff would have need to be delineated. This is huge. I mean, if you are working in the day room and some kid tells you that another kid just grabbed their butt, let's say, for example, you need to know what to do about that. And you need to be very clear about how to handle that. That's where we delineate those responses. But I can tell you that all reports of sexual assault, abuse, and harassment will be investigated, and either by at least an administrative agency for the purpose of investigation. Okay, so in our case, likely that would be Children's Division, would be a administrative agency to investigate, and then as needed, or if applicable, a criminal investigation by the police department. But you know, when a response to a report is to investigate, right? Who's going to investigate? Well, we either want Children's Division or law enforcement, but we have to have a written process to make those referrals. Then a response to the report, once it's investigated and a finding reached, then a response would include discipline for those involved. And we'll go over that more. Actually, that's one of the components. And then protection for the resident and staff, again, for retaliation, against retaliation for reporting. So if someone makes a report in good faith, they need to be protected. There should be no consequence for that. Okay, we already talked about one of the responses to the report is going to be an investigation. What's that going to look like? An administrative investigation by some agency, likely Children's Division, will be conducted for all reports. Some kind of investigation will happen for all reports. It is best if that investigation happened by someone outside of the detention center for several reasons. The least of which is not that whoever does the investigation should be specially trained in sexual abuse investigations involving juvenile victims. Well, I wouldn't consider myself trained in investigating sexual abuse investigations involving juvenile victims. That needs to be referred to an agency or a group that can come in and do those adequately. And that is part of the standards, is that it needs to be done by someone who knows what they're doing. And then the evidentiary standard for these administrative investigations is no more than the preponderance of the evidence, which is a little bit less of a standard than what a criminal, guilty, if someone was charged criminally and prosecuted, the standard for a finding of guilty is a little bit higher than the preponderance of the evidence. And then another part of this process, according to the standards, would be that the resident who made the report needs to know the outcome. Now, we don't have to go into gory details, and it doesn't have to be a gossipy thing, but that kid needs to know it was investigated and this is what happened. There should be some outcome reported back to the resident. I told you we were going to get to discipline. Discipline is one of the components of the PREA standards. If during the process it is a staff person who is found to be engaging in sexual harassment, abuse, or assault, then they would have some kind of consequence with termination of employment, the presumptive disciplinary action for sexual assault. I think that pretty much goes without saying. Corrective action for contractors and volunteers could range anything from just a remedial measure to, I don't ever want to see you again, you don't have any place in this facility, and no more contact with residents. An intervention and disciplinary action for residents who engage in this kind of behavior can include isolation, treatment, or other sanctions. Okay, this is the component, medical and mental health care of the PREA standards, that says when an intake screening indicates that a resident is a victim or a perpetrator of prior sexual abuse, whether it occurred in an institutional setting or in the community, that resident shall be offered a follow-up meeting with a medical or mental health practitioner within 14 days of intake. Now, how often do we see, you all might be thinking, well, we kind of do that, right? We do, don't we? Because when a kid comes in, we have our medical and mental health screening process. We ask the kid, have you ever been sexually or physically abused? Quite often, it's not unheard of by any means that a kid would say yes, that they had been. Or they might come in and the screening indicates that they've been sexually harmful to other youth. And so in any event, we want to make sure that they see our contracted mental health provider within 14 days, and that information is communicated so that can be addressed by the mental health counselor, in addition to the suicide assessment that they may do. A kid in detention who is subject to sexual assault or sexual abuse, if it so requires, they should have access to emergency medical and mental health services. So if a kid is brutally assaulted in a detention center, they should be able to get emergency medical attention right away. And of course, we would want to make sure that they get to the hospital. And then they should have ongoing medical and mental health care for sexual abuse victims and perpetrators to be provided. So we want to make sure if someone is harmed within our detention facility or someone perpetrates within our detention center, that is addressed, and if they need medical or mental health care immediately, and that it's ongoing, that's wherever they go, that there's going to be some continuation of any treatment that they may need. Data collection and review. Data collection and review is a component, again, of PREA, which I think that we are fortunate to be able to, with our grant money, partner with the performance-based standards and the Council of Juvenile Correction Associates to do data collection, data monitoring, and so forth. Because really, it's a holistic approach. You look at all of your indicators that kind of tell you, if you have any issues or problems. If you have a holistic, healthy environment, you're going to definitely reduce your incidents, right? But any incidents that do occur need to be evaluated. Obviously, we would have an incident report. The whole thing would be reviewed by an upper-level management official. And then all data would be collected and aggregated annually, and according to PREA standards, should be reported to the public. All data, we can look at our incident reports and say, we could have done this a little bit better, or if we had just done this instead, this might not have happened. So data is to be reviewed for corrective actions. If there's any improvements that you can make based on the data, that is a component of the standards that you are to attempt to try and do. And the data is to be maintained for 10 years. The last component of the PREA standards is audits. Audits are to begin this year, in 2014, and take place every 3 years. I can tell you that on the state level there is some discussion that DYS is having with OSCA and with MJJA, the Missouri Juvenile Justice Association, about how to get those audits done so that they can ensure that the people that are holding their kids under contract for them are PREA compliant. So we can expect that there will be some audits coming down the pike. I don't know what they're going to look like, but they will happen. I will tell you also that nationally, there's a number of people that have been going through training to be PREA auditors. So nationally, there's some gearing up going on to identify and train potential auditors. And Barbara Chait, who is our PBS coach, recently was trained as a PREA auditor. So I think we'll have some good help there on integrating, making sure that we're doing what we need to do and that we're collecting the data to ensure and to demonstrate that we're doing what we need to do. So the implementation process, so this is all well and good. We've got these standards, we understand what the standards are, but then how do we move to the next step of implementing them and so forth. And basically, there is a toolkit called the Prison Rape Elimination Act, a toolkit for juvenile agencies and facilities, which we have completed. Joel, our assistant detention superintendent, did do the toolkit. And the purpose of the toolkit is basically you go through the standards step by step, and do you do this or don't you? Do you do this, do you not? And that gives an opportunity to assess what's currently in place and where are our gaps, and then develop some strategies to fill those gaps. And then to write a policy and procedure based on local resources. I think it's really important to know that everybody's policy and procedure is going to be just a little bit different. That just because we're neighbors to the Joplin Detention Center, their policy and procedure is going to be look different than ours because of our culture, because of our resources being different, etc. So we have to write our own policy and procedure. It doesn't hurt to look at other people's, what they've written, but we have to come up with something that fits our detention center. And everybody has to do the same. And then we have to train staff on what those policy and procedures are and monitor for compliance. So that's basically how you implement something like this. So, when we write the policy and procedures, and we talk about writing them based on local resources, some examples of resources would be there are policies and procedures that have been developed by other state detention centers, like St. Louis City has one. We can look at those and go from there, see how we might want to change or modify depending on what our resources are. We can count on our county human resource department and for other detention centers who are state employees, the OSCA Human Resources Department, to assist with background checks and discipline of employees if needed. And that's already in place. That's a resource we already have. That's something we already do. We can employ and schedule both genders as staff, making cross-gender pat-downs and viewing unnecessary, which is not anything we would do anyway. Even if we had all males or all females on a shift, if we had someone come in of a different gender, we're going to try and get somebody in. But that's a lot of tension, and it's a lot of things that, presents a lot of problems that could be avoided if we make every effort, which we will, to make sure that we have both genders on all shifts. We can count on the Juvenile Division Education Committee to assist with training needs. One training that is available is the mandated reporting training through Children's Division, which we did do last year in 2013. We did a mandated reporter training and maybe should look at doing that regularly. There's example screening tools. We talked about when a kid first comes in, we need to talk with them, get information from them, and use that information for determining what programs or placement in the program. But those screening tools like that are available through other detention centers, but mostly I think our biggest resource there would be the Division of Youth Services. The Division of Youth Services has a PREA compliance employee. That's her whole job, is to make sure that all of the facilities and all of DYS is PREA compliant. So they have some tools that we can definitely use. And then I think I already mentioned that OSCA, the Office of State Court Administrators, is working on developing a screening tool right now that we will definitely want to look at. Other examples of resources is to modify our existing grievance process to being compliant with PREA standards as one avenue for residents to report. We can use victim advocates in the community to provide additional reporting and treatment resources. I think that's one of the great things about the group that we have from the Victim Center right now that Melinda is doing, is that that's sustainable. That's their mission, is to receive reports and to teach people how to report and so forth. So I can see us continuing using those resources. And there's other agencies in the community as well that would be very valuable to provide additional reporting and treatment resources. Another example of a resource is grant funding. We can continue to look for grant funding from the PREA Resource Center, Title II, et cetera. Any place that we can go to get grant money to support these efforts, I think that it's a good use of our grant writing skills and time. We can collaborate, and we'll need to collaborate with Children's Division and local law enforcement for investigation purposes. Right now, it's just kind of an assumed thing, like maybe if we call the police, they're going to show up, or if we make a referral to Children's Division, they're going to do an investigation. But I'd like to firm that up with a memorandum of understanding so that we're all on the same page, especially when it comes to our response to a report, that we know who to call, what to expect, et cetera. And then we'll, if at all possible, continue with performance-based standards. That's a 20-year-old program that provides a process where we can collect performance outcome data, which we were supposed to review last Monday, but due to the weather, we didn't get to. But we do have a lot of opportunities through PBS to look at outcomes for our operation and to kind of review those for continuous improvement and use performance-based standards to help us with the PREA compliance. And then lastly, when we're talking about resources, one that I do not want to forget, don't want to ever forget, and I hope that no other detention superintendent or other administrator forgets, that the biggest resource is the staff. The biggest resource that we have going for us is the detention staff here in Greene County. And if it weren't for the staff, you know, where would we be? You guys are the ones who take care of the kids. You are the ones who talk to them, listen to them, observe them, discipline them, and so forth. You are the ones that really give, you know, is where the rubber meets the road. And I'm appreciative to work with such a great staff. I definitely can consider the detention staff as a resource, and I'm looking forward to working together as we work through these PREA standards to improve and to move forward in a really positive direction. The last group, one of the concerns was false allegations. Like, what if a kid gets mad at a staff person? They didn't ask it this way, okay, so I'm elaborating or embellishing the question. But what if a kid makes a false report against a staff person? You know, how's that going to play? And again, all reports will be investigated. And I think the best answer to that is what we're going to give the kids. And on here, it talks about their facts related to sexual assault, abuse, and harassment. It says sexual assault is a crime, and all sexual assaults are to be reported and will be referred to the proper law enforcement and child protection agencies. Each report will be thoroughly investigated and the appropriate action taken in the best interest of everyone, especially the victim, and all voices will be heard. False allegations against someone will result in consequences. So the kids are getting that. We want you to report, but if you make a false accusation, there could be consequences for that, because everything is going to be thoroughly investigated. And there's the answer to that question. It's possible. It's entirely possible that when you when you go down this road that, you know, you might get a allegation that's false. But, you know, we do have a process in place, or we will have something firm in place in writing that would allow for an investigation and all voices to be heard. It's kind of like with the hotline, right? People say, oh, you know, you can make a false allegation and this and that. A lot of people make false, even with our ex parte orders that we do. You know, people make stuff up, they make false allegations, they embellish, they lie, what have you. But for the one case or the one time that somebody got the help that they need, the protection that they need by reporting, it's all worth it. So yeah, we kind of open ourselves up to some liability, some false reporting, but it is so worth it to be able to protect kids. Because remember, they can report, you know, it could be a staff to resident, it could be a resident to resident, and it can be a volunteer to resident. So we need to know what's going on. Okay, well, I don't want to take too much time because our next presenter is Jim Myers, and he is a professor at Missouri State, and he's going to be talking about adolescent sexual development.